going to get us started with the case of Pauline Whitecross Dental Care. Now, the claimant in this case was treated by the defendant's practice over the course of a number of years by 4 different dentists, all of which she alleged had provided negligent treatment. Now, when she came to issuing the claim, she issued against the defendant's dental practice rather than the 4 individual dentists. And the practice stated that it wasn't vicariously liable for the dentists as they were self-employed. But rather than joining the dentists into the action as third parties under Part 20, the practice applied for them to be joined as additional defendants under Part 19. The claimant opposed the application on the basis that she couldn't be forced to bring proceedings against the dentists and ultimately possibly become liable for their costs. Now, at the first hearing, the defendant's application was granted by the district judge. The judge held that the lack of consent by the claimant to adding the defendants to the action wasn't a determinative factor, and instead the question was whether it was desirable to add the dentists. She ultimately found that it was desirable given the rights of the dentists were affected by the decision in the case, and also the possibility that if the claimant lost on the primary issue of vicarious liability, she may then seek to bring a second action, this time against the dentist or her legal advisors. Now, that decision was upheld by a circuit judge on appeal. Again, the judge found that pursuant to Part 19, specifically 19.2.1, there was no jurisdictional bar to adding a party against the will of the claimant. And essentially, the circuit judge took the same view as the previous court, that the court's entitled to take into account all of the circumstances, including the overriding objective and issues of delay and wasted costs if the claim were unsuccessful and a second claim brought. Now, the matter did reach the Court of Appeal, where the decision was then overturned, and the Court of Appeal helpfully clarified that although the rules under Part 19 are wide enough to allow a defendant to be added, even where the claimant opposes that, it would still be wrong in principle for the court to exercise that power in circumstances like the present case. And essentially, a claimant who is competent to litigate is entitled to bring claim against whoever they want to. There's nothing about this specific claim that was abnormal, and there was no reason for the court to interfere with the claimant's decision. Ultimately, she had sound reasoning as to why she'd chosen to sue the dental practice over the individual dentists. And even in circumstances where that choice might expose her to a greater risk of not succeeding than would be the case if she'd sued all the potential defendants, the court shouldn't force her to bring proceedings against other parties. Now, that being said, it was acknowledged that there may be some exceptional circumstances where it may be appropriate to join a defendant against the claimant's wishes. The only example that I could think of, or the only good example I could think of where different considerations might apply was in the context of a group litigation order. But generally speaking, following poorly, applications under Part 19 without the consent of the claimant are unlikely to succeed unless there are exceptional circumstances. Although it's not all doom and gloom, because even where there aren't exceptional circumstances, Part 20 still continues to offer an alternative route for defendants to proceed with contribution indemnity. So, moving on to the next case of Soderberg and Essex partnership. So the relief from sanctions case, the background is that the claimant was under the trust's psychiatric care. She attempted to commit suicide and suffered serious injuries as a result. The trust had some difficulty in collecting all of the relevant medical records, and approximately 4 months before the listed trial date, further information became available, and it became clear that 2 further individuals should be asked to provide witness statements. Now, the problem was, of course, it was close to trial, witness statements had already been served the previous year, so it was necessary for the trust to seek relief from sanctions. Now, in making the application, the trust accepted that the breach was serious, but it was emphasised that there'd been no deliberate flouting of the rules, the cause of the late witness statements being the problems encountered with collecting the medical records. And the breach was also said to not be significant given the trial date wouldn't be jeopardised and the claimant wasn't prejudiced. The most important factor was essentially the position of the court, because this was quite a complex case and the court needed all the relevant information before it. So the records and the documents that had come to light and that underpinned the additional witness statements would be before the court anyway. And it was said that it would greatly assist the court to be able to hear from those witnesses. The application was granted. The next case I've got is another relief from sanctions case. Not quite as straightforward for the defendant in this one. They did receive a bit of a slap on the wrist by the court. I won't go into the detail of the case because it's not important and it's definitely not interesting. But in summary, the defendant failed to comply with an order to produce key documents ahead of an application. At the hearing, instead of addressing the failure to comply head on, defendant counsel had tried to skim past the non-compliance and didn't make full submissions in relation to relief from sanctions. Now, the judge respectfully suggested to counsel that the defendant might wish to reconsider that decision and might want to make a full relief from sanctions application. So after a short adjournment, defendant counsel returned and unsurprisingly made a full application for relief from sanctions. In the judgment, the judge stated that the court's patience was being sorely tested. However, the application was granted. I've thrown this one in because it's just a useful reminder of the importance of making a relief from sanctions application as soon as it becomes evident that there's been non-compliance. And it's a reminder that the application should be dealt with properly rather than skimming over it in the way that the defendant seemed to be doing in this case. Well, moving on to Hughes and Rattan. The defendant in this case was the owner of a dental practice, and the claimant's claim was in relation to treatment provided to her by 4 associate dentists at the defendant's practice. Now, similar argument to the case previously, the defendant denied that he was liable either through vicarious liability or a non-deligible duty of care. Ultimately, the claimant was successful at first instance in relation to both issues of vicarious liability and non-deligible duty. The decision was then appealed and both issues were considered by the Court of Appeal. So dealing first of all with the non-deligible duty, there's 5 criteria identified by Lord Sumption in the case of Woodland and Swimming Teachers Association, and those criteria were considered in Hughes and Rattan. So ultimately, the claimant was successful in relation to non-deligible duty because first of all, the claimant was a patient and therefore dependent upon the protection of the defendant against risk of injury. Secondly, an antecedent relationship between the defendant and the claimant was established on each occasion, and the claimant signed a personal dental treatment plan, which she was required to do before NHS treatment was carried out. So this placed the claimant in the defendant's care because he was the owner of the practice. And it was said that the duty was a positive one to protect the claimant from injury, and it involved an element of control over the claimant. Thirdly, the claimant had no control over how the defendant chose to perform his obligations. So, for example, when she called the practice to book an appointment, she was able to express a preference in relation to the choice of dentist, but that was only a preference, and it was ultimately up to the defendant in relation to which dentist she saw. Criteria 4 and 5 weren't issues. just very quickly there that the defendant had delegated to a third party a function that was integral to the positive duty owed, and lastly, that the party had been negligent in how it performed that function. So the appeal was dismissed on that basis. Although the claimant was successful in relation to non-deligible duty, the court still went on to express its views on vicarious liability as well. And the defendant's argument was essentially that the judge had placed too much weight on factors suggesting the defendant's relationship with the associate dentist was akin to employment, and insufficient weight to factors pointing in the other direction. Now, ultimately, the Court of Appeal found that the relationship was not akin to employment for the following reasons, most of which seem to be focused around the amount of control. So first of all, the dentists at the practice were free to work as many or as few hours as they liked. They were able to work for other practice owners if they wished, different businesses. So there was no mutuality of obligation in that regard. The defendant also had no right of control over the clinical decisions made by the dentist or the manner in which the treatment was carried out by them. It was also taken into consideration that the dentists were responsible for their own tax and national insurance payments, and they were treated as independent contractors by HMRC. And lastly, the dentists were required to indemnify the defendant against any claims made against him in respect of treatment of their patients. So this case is a really good case to come back to if you do have a claim where you need to consider non-deligible duty and vicarious liability, because it sets out quite a few factors that work both in favour and against each finding, particularly where there's no clear employment relationship. So the next case is one of material contribution, Thorley and Sandwell. And it deals with adverse inferences where a party chooses not to disclose or rely on evidence. So the background to this case is that the claimant was told to stop taking anticoagulants prior to undergoing an angiogram. And as a result, he'd suffered a stroke. Now, the claimant argued that the advice to stop taking the medication was contrary to a guidance document that was called Anticoagulation and Surgery. Now, this guidance document hadn't initially been disclosed by the defendant because the defendant took the position that it wasn't directly applicable to angiograms, it was only applicable to surgery. So the matter went to trial. The claimant's expert stated that the guidance was applicable and should have been followed, which ultimately would have meant that the claimant only stopped the medication for 3 days rather than 4 days. The defendant's expert maintained that the guidance wasn't applicable as angiography is not a surgical procedure and therefore is not covered by the scope of the document. Further, it stated that the guidance wasn't protocol or policy. So in absence of a specific protocol relating to angiography, it was not reasonable to apply the guidance relating to surgery. Now, the interesting part is that the defendant didn't bring any factual evidence in relation to the guidance. So there was no evidence from those that drafted the guidance, and there was no factual evidence from those that had treated the claimant specifically in relation to the guidance. And the claimant sought to rely on the defendant's failure to bring that evidence by inviting the court to draw an adverse inference. Now, when the court considered adverse inferences, it considered the case of Winewski, and essentially what that case says is that the court may be entitled to draw adverse inferences from an absence or silence from a witness who might be expected to have material evidence to give on an issue in the action. However, there must still be a case to answer on the issue, and there must be no credible explanation as to why that witness did a Supreme Court case of Afobe and Royal Mail Group. This is actually an employment case rather than a clin neg or PI case, but the same principles still apply. Basically, what Afobe says is that the matter of adverse inferences should be simplified, and it should simply be a common sense approach that's taken. The judge found that no adverse inference should be drawn by the failure to call factual evidence, and the defendant's expert had provided his interpretation of the document, which the judge ultimately preferred over the claimant's evidence. Moving on to my last case, C and Z. This is a case involving a claimant who was a second-born twin, born in 1996. She was left profoundly disabled as a result of suffering around 16 minutes of acute profound hypoxia. The judgment for this case was published just last week, and it has significant complications for both Montgomery and material contribution. So, dealing with the Montgomery point first, the headline is essentially that Montgomery applies to decisions made intrapartum in the delivery room. So in this case, the mother had point blank refused artificial rupture of the membranes and had insisted on a caesarean section a number of times. However, despite her preferences, they still went ahead with rupturing the membranes without her permission being obtained. Now, previously, because of factors such as pain and stress just before mothers are about to give birth, the courts have been reluctant to apply Montgomery in the context of imminent delivery. My view is that that's an overly paternalistic approach. So I was very happy to see that in the present case, the judge had held that the mother's request for a caesarean section should not have been ignored. That should have been taken into account. Now, the other significant finding in this case in relation to material contribution was that acute profound hypoxic ischemia is a divisible injury to which material contribution applies. So the conventional understanding in these types of cases, essentially the first 10 minutes is generally non-damaging, and after around 25 minutes, the baby is unlikely to survive. Now, in this case, it was accepted that every minute of acute ischemia after the first 10 minutes causes more than minimal damage. So even though it's not possible to work out the functional outcome, which would result from a shorter insult, a claimant is entitled to damages in respect of 100% of her injury, even if she would have suffered some injury in any event. So pretty groundbreaking stuff, but on that note, I'm going to hand back over to Abby.
Thanks, Jade. Sorry, I'm just going to start my camera. Excuse me. I'm having some difficulty starting my camera. There we go. Sorted. Wonderful. Thanks, Jade. Really useful cases, and particularly in relation to those issues of material contribution and those maternal cases, which we know there are so many of them. I'm going to move on and deal with a few other matters in terms of the substance, but then also issues in terms of fundamental dishonesty, costs, those sorts of issues. But my starting point actually is secondary victims, because we all know that secondary victims in clinical negligence cases are problematic. The reason they're problematic, of course, is that we have often that gap in time between the initial negligent act and then the damage that is subsequently suffered in terms of the secondary victim, for example, witnessing somebody's deterioration or death later down the line as a consequence of the initial act. Paul and rural Wolverhampton is probably not a fair description, because we know that there are 3 joined cases here. You've got the case of Paul, you've got the case of Polmere, and you've got the case of Purchase. Just to remind everybody of the facts of those 3 cases, Paul is the case where a gentleman attended at hospital. He then, a year passed, whereupon he then collapsed and hit his head whilst he collapsed. His daughters witnessed that collapse and suffered psychiatric injuries as a consequence. That gap in time, in terms of the first instance and the Court of Appeal decisions, was said to be the problem in terms of the issue of secondary victims. It was too great a gap in time, and therefore it could not be allowed to stand in this case. Essentially, the courts are bound by the Alcock test as applied in Taylor and A Novo, which didn't allow the shocking event to be removed in time and space from the original negligent act. And that is in fact the conclusion that was also reached in the 2 linked cases of Polmere and Purchase. Polmere is a misdiagnosis case in which essentially there is a misdiagnosis. 6 months later, the patient collapses and goes into cardiac arrest. Parents attend, they attempt CPR. Unfortunately, that is unsuccessful, but the parents suffer PTSD and depression as a consequence. And the final case, which is they're all sad cases, but the final one is particularly, you can imagine the upset, is a case of Purchase, which is a pneumonia misdiagnosis case. It's misdiagnosed as a respiratory tract infection. The claimant goes home, and her mum 2 days later goes around to her house and finds the claimant unconscious, but she's got her phone in her hand. There is an attempt at resuscitation, but that's unsuccessful. But the deceased mother then finds a voicemail from the deceased, in which essentially it's the recording of her last few minutes of life, which you can understand then leads to the deceased mother suffering with post-traumatic stress disorder and psychiatric injuries, leading her to her bringing this claim. The conclusion and the Court of Appeal is, as I say, that at the moment those claims could not stand because of the difficulty in the shocking event being removed in time and space. The reason I flagged this up to you is actually because this is, of course, a matter that is going to be heard by the Supreme Court. Kate will talk about that briefly at the end, but we know it's important, and we know that it will be important whatever the Supreme Court decides, because the classic test in terms of secondary victims often doesn't work or fit in clinical negligence cases. And so I would really urge everybody to keep an eye out for the Supreme Court decision when it comes later this year in terms of these matters, because I think it will be a significant and important one. We know that Sir Geoffrey Voss, in terms of the Court of Appeal, is critical of the way that the current test is applicable in terms of clinical negligence. If that same criticism is reflected in the Supreme Court, then we might well have a shift in approach. The next case we have is Matthew and Hines. Before I go any further, I should give credit to Tom Vonberg in Chambers, because he's got a lovely article, which is a really nice case summary and analysis of this. So I'd really recommend anybody go away and look at this. It is a case in which a claimant suffered a traumatic brain injury. The dispute was in relation to the issue of provisional damages and whether or not they ought to be awarded in circumstances where, excuse me, I'll deal with any questions at the end, sorry, thanks. In terms of the provisional damages claim, in terms of whether the elevated risk of dementia, as was being claimed by the claimant, should therefore result in a claim for provisional damages. The court spent quite a lot of time with this because the court said that you really needed to have a thorough analysis of the state of the medical evidence as it existed at the time of the hearing. And the problem that the claimant had in this case was that essentially the claimant couldn't get past the fact that the state of the medical evidence did not satisfy the test that there had to be a more than fanciful chance of the development of disease or deterioration. And so that threshold wasn't quite met. However, the reason this one is important is the state of that literature as analysed by the judge makes very clear that the direction of travel in terms of medical evidence is very much in the direction that we are going to be able to establish that the increased risk of dementia is something that follows on from a traumatic brain injury. And so keeping an eye out and being alert to the current state of the medical evidence, but also really pinning down your experts so that they are completely up to date on whatever the most recent literature is going to at some point result in us reaching a tipping point where we are able to, for the sake of claimants, get over that threshold. Of course, if you're for a defendant, then what you're going to want your expert to do is to have a look at that expert evidence, pull it apart a little bit and say, well, what's the basis of it? Is there really a good enough sample size? Is there really a good enough methodology? All those sorts of things. So again, interesting and also demonstrates really the direction of travel where we are at the moment with cases. We then move on to fundamental dishonesty. The issue of fundamental dishonesty is one of those that I think everybody has a simultaneous love-hate relationship with. We hate it because if you have a client who is fundamentally dishonest, it's awful. In some ways you have to love it because there is always a degree of drama which makes the cases incredibly interesting to read, albeit I might say that from a position of being a barrister who quite likes a dramatic case. But the first case I flag up is one that I would like you to bear in mind in the context of the second case, because the two cases that I'm going to refer to here have fairly similar sets of circumstances and facts, but they result in different outcomes, demonstrating that if you are for a claimant or defendant, in circumstances where you are making applications for contempt of court, there can be a variety of outcomes. None of them are going to most likely be very positive for the claimant, but there are varieties, and therefore it is a little bit difficult to predict how they might go. The first case is this case of Hull and Colley. This is a case in which the claimant was originally represented by her litigation friend and mother, because she was born with a serious disorder of the hips, which she said hadn't been adequately dealt with and treated at birth and in the years thereafter. The problem for the claimant's litigation friend and mother was that she made a series of false statements about the condition of the claimant. They didn't relate to the early years, which was where there was a lot of argument between the experts, but actually about later years when the claimant was in secondary school. By way of example, the claimant's mother said that the claimant was wheelbound and wasn't really able to actively participate in any meaningful way. But there emerged theatre videos, and those theatre videos demonstrated the claimant in leading roles, singing and dancing. The defendant also obtained statements from the claimant's teachers, demonstrating, again, explaining that she was able to do all sorts of things that the claimant's mother said that she definitely wasn't able to do. The additional factor was that during proceedings, the claimant turned 18, and the inquiries made pretty clear that what had happened was that prior to her being 18, the claimant's mother had encouraged her to lie as well. As a consequence, there was always therefore a risk that the defendant would seek contempt of court proceedings, not only against the claimant's mother, but also the claimant herself. The claimant actually abandoned her claim. Once the dishonesty came to head, she abandoned her claim, but the defendant nonetheless pursued a claim of pursued contempt of court proceedings against her mother. They were very concerned about the level of dishonesty. Ultimately, the claimant's mother was given a 6-month suspended sentence for 2 years. Interestingly, in that respect, she actually made no admissions. The court concluded in terms of her sentencing that she, although she hadn't made any admissions, they had nonetheless reason to believe that she had learned her lesson, albeit that that's a little cryptic. And I was interested that the court took that into account as a mitigating factor in circumstances where she hadn't admitted that she had been dishonest. But what seems to have really been the key issue here was the fact that the claimant had a 6-year-old son who had significant medical issues. And from my reading of this, that seems to have been a significant factor in tipping this case over into the suspended sentence rather than an outright sentence of imprisonment. The reason I go through the detail of that is because we then turn to the next case, which is that of White. White's a Claude Equine case. Claim is originally valued or claimed at 4.1 million, not including general damages. There is an agreement in terms of the level of damages at 50-50, with, of course, the extent of those damages to be assessed based upon the expert evidence. The claimant made very detailed statements setting out the things that she could and couldn't do, and in the way of these things, videos emerged showing that she could do the various things that she said that she couldn't do. The defendants at that point gave the opportunity to the claimant and said, look, if you want to discontinue and walk away, we won't pursue any order as to costs. But the claimant maintained that she was honest and proceeded. There were a couple of other instances where there was the opportunity to walk away, but no admissions were made by the claimant in terms of any dishonesty. There was then an application, the claimant then failed to comply with directions, which resulted in a hearing whereupon her claim was struck out. At that hearing, the claimant attended and acknowledged that there were allegations being made of dishonesty against her. But again, at that stage, we still not got admissions being made by the claimant. Ultimately, where we ended up with contempt of court proceedings being brought against the claimant. The claimant waited until the night before those contempt proceedings to make full admissions such that experts were no longer required at that hearing. Ultimately, the following day, the court was very unhappy, and the claimant ended up being sentenced to 6 months imprisonment. There were the usual arguments in terms of and findings that defrauding the taxpayer-funded organisation is unacceptable. Patient presented a risk to the public purse and public institutions, which, to my mind, apply equally to this case as they did to the last case. But what was also taken very significantly into account is that the steps went beyond mere exaggeration. There was the misleading of many experts, which of course then led to the increase in costs. And then the additional factor, which related to the claimant's son. The claimant had an 8-year-old son, and she argued that essentially by imprisoning her, there was interference with her Article 8 ECHR rights to a private family life, and also those of her son. The court took that into account, and it clearly carefully weighed that matter against the legitimate aims of sentencing, as the court put it, and ultimately decided that imprisonment was appropriate in this case, and it wasn't appropriate for there to be a suspended sentence. The key difference from my reading of these two cases is this. The 8-year-old little boy, who was the son of the claimant in this case, appeared to have a different network around him. So he also had a grandmother and father who were quite involved, and they were acted as carers for him as well. And it seems that that was at least one of the significant factors that might well have resulted in this being a non-suspended sentence rather than a suspended one, as in the case of Collie. All right, we move on to costs. The first case is the case of Dance. Before I go any further, actually, I should flag up, these are all cases in terms of costs where things that might seem obvious to some people are in dispute, and there is value to those cases because they do provide that clarification. The case of Dance is a case where we're dealing with the recoverability of an ATE premium after the acceptance of a Part 36 offer. The defendants argued that when you settle by way of Part 36, and when you consider CPR 4411, an ATE premium technically isn't a cost within the meaning of 44.1. They also argued that a Tomlin order or Part 36 or settlement in one of those two ways doesn't amount to an order for costs, which therefore means the ATE premium can't be considered a cost because it doesn't amount to an order for costs. The court was quite critical of this, and it said that when we consider the cases in terms of settlements and Part 36 and the methods of settlement, which we'll touch upon again shortly, it wasn't open to the court in Cartwright to conclude that acceptance of a Part 36 does not give rise to an order for cost. Therefore, the same applies here. And moreover, following the case of Stamford Hospitals and McMenney, CPR 44.1 definition of costs had to extend to recoverable ATE premiums in clinical negligence cases. And so, for the avoidance of absolute doubt, there is now this indication that ATE premiums are recoverable. The next case is the case in terms of the extension of time of Part 36 offer, and it deals with that issue that we often have, which is that you either receive a Part 36 when your medical evidence is incomplete, or you want to make a Part 36 offer in circumstances where the medical evidence is incomplete, but you're wanting to protect yourself in some way. And it's quite useful little guidance in this sense, and it's relevant in terms of one of the other cases we'll touch upon shortly. But in this case, you have a protected party claimant, and the protected party claimant receives a Part 36 offer. But their solicitor is concerned by this because they don't feel that they're in a position as yet to accept that offer or decline it because they've not got their completed medical evidence. And so they say, well, we don't feel like we can accept or refuse this offer. And so they apply to the court to extend the relevant period for which there is acceptance of the Part 36 offer pursuant to CPR 36.3G. And the power for that, they said, came from CPR 3.12A, which is the discretionary power of the court to extend time for compliance or shorten the time for compliance with rules, practice, directions, or other court orders. The court refused to get involved. The court said no. The use of 3.12A wasn't appropriate because in this case you weren't dealing with the issue of compliance with an order. What you were dealing with was a self-contained regime under Part 36. And under Part 36, if an offer is made, then you have to consider that, bearing in mind the various risks you're dealing with. And there is no express power within the civil procedure rules to allow the courts to rewrite the terms of a Part 36 offer that a defendant has chosen to make. The court really emphasised the importance of legal representatives using their expertise in assessing these offers. What that ultimately means is that we are in a position with these cases where you are, when you are faced with these offers, required to make these judgment calls. And in cases where you have a protected party like this, it's going to be all the more important that those considerations are properly laid out in an advice, because we know the court is going to want to see an advice before they approve any settlement. And so we can't get around Part 36. All we can do is make risk-based assessments. The next case concerns the circumstance where a Part 36 offer is received. It's not accepted at that point. But later down the line, there is a decision to accept Part 36 offer. But there has been in the interim period the ongoing receipt of benefits that will be offsettable under the CRU regime. And as you all know, in that circumstance, the court has to give permission for that offer to be accepted. The reason being is that there is, of course, going to be a different amount to be deducted from the damages in terms of those recoverable benefits compared to the point at which that Part 36 offer was made. Which means that you can well have a case in which there is a Part 36 offer which is being accepted by a claimant subject to the court's permission, and the court therefore has to make an order. And if the court is making an order, then the defendant says, well, hold on a minute, we had that application 2 years ago that we were successful in and got a costs order in. We'd like to offset that against the damages. The court's making an order now. Under the Quox rules, we would like to offset against this. And that was the defendant's application ultimately. They said that in the circumstance where a court is dealing with these these permissions, that there is a court order, and therefore they ought to be permitted to essentially enforce their cost orders against the damages that are being awarded to a claimant, as they put it. The court disagreed. The Court of Appeal was very clear about this, that box protection is retained. They said that essentially the order that they are making is not an order awarding damages. All it is essentially is a redirection of some of those damages to an appropriate place. They were very conscious of the impact upon cases, for example, where you have settlements and protected parties, because in those cases, we know that the court has to approve a settlement before anything can be finalised. And then as a consequence, in this case, we therefore see that there is no way, for example, the defendant to get around the box protection in cases where you're accepting a Part 36 out of time with the court's permission. However, this leads back to the issues that we know are live as a result of Ho and Adilkin from last year. This question about the circumstances in which a defendant can offset any cost orders that they have against damages. At the current time, we know, of course, that if something is contained within a Tomlin order, it's not classified as an order of the court, and therefore, essentially, the defendant can't offset. But we also should be very much aware that this is going to change. And the reason this is going to change is that the Rules Committee has agreed this proposed amendment to CPR 14.1. And that essentially, it means that there is the intention to change the rules so that it involves agreements to pay as well as these awarded sums. And so this is a rules change that we need to be conscious of, like being likely to take place later this year, likely this year, possibly next year. This case is a case that's very similar to the previous case that I mentioned in terms of incomplete Part 36 offers of bay gum. It's not actually a clinical negligence case, but it does have the implications in terms of implications for clinical negligence in the same way as bay gum. It's a technology and commercial court case in which we're again dealing with the issue of Part 36 offers not being accepted in circumstances where there was incomplete evidence. The facts of the case are really not overly important, but what was important was this this paragraph that was given by the court, which was, I reject the defendant's contentions. As to the first part, parties frequently face the pressure of a Part 36 offer without all of the pieces of the jigsaw in place. Much of the purpose of Part 36 would be lost if it were otherwise. The costs which the regime was intended to prevent being incurred would have to be incurred before the normal consequences of the offer could flow. A well-judged Part 36 offer is often based on inspired and educated guesswork, which the other party must also display when deciding whether to accept it. The only way around this, of course, is if you can demonstrate that the giving effect to that Part 36 would be unjust. You can absolutely see how this might apply for certain clinical negligence cases, but you can also very much see that when you have a prognosis that is very much up in the air, or you're dealing with protected parties where you have an unclear outcome, that this could potentially result in some lack of justice, or it might be perceived as lack of justice to certain claimants. It places a lot of emphasis upon the skills and the experience of those representing claimants and defendants for that matter, which I think is intended to be a pat on the back, but actually I think for many people will be viewed as increasing the pressure. It is something that is important. It is something that should be borne in mind whenever a Part 36 offer is being made or is received. We have the last case from me, and I will be fairly quick with this one because essentially it is just a case where it deals with quox protection again. And it's quox protection in a legally aided case, however. The claimant brought a claim against two defendants. They succeeded against the second defendant, but failed against the first defendant. And they were therefore ordered to pay the first defendant's costs at the conclusion of the case, not to be enforced without permission in the usual way of these orders. The case against the second defendant then settled by way of Tomlin order. And we know, pursuant to Cartwright, and as I mentioned earlier, that therefore isn't an award for damages and interest. The defendant said, no, this is a legally aided case. And because it's a legally aided case, there isn't court protection. And so we should, the first defendant said, we should be able to enforce our costs order against the damages that have been awarded in the agreement with the second defendant. The court took a detailed look at this. Ultimately, they said no. There is no specific exception provided in CPR 4417 in relation to legal aid. And as such, we remain in the position where, pursuant to Cartwright, it's not an award of damages and interest, and therefore the first defendant can't offset their costs against the damages that are agreed with the second defendant by way of the Tomlin order. The other factor to bear in mind from this case is it made absolutely clear that an interim payment that had been received was also not an award for damages under CPR 4414. And so again, it isn't something that can be offset against, or costs are not something that can be offset against that either. There's quite a few costs, so there's quite a few implications of these matters. I think we are still, even some years later, resolving some of these Crocs issues. I think there should be a bit more guidance this year from the Rules Committee that will inevitably lead to further case law as a consequence, but it's very much worth keeping your eyes peeled in terms of those. I've no doubt that we'll be doing a case law update again later in the year that will very much touch upon those issues. Right, conscious of time, we're very much almost done. Kate, I'm going to ask you to just round up in terms of what to expect from the year ahead in terms of key cases and decisions, if that's okay.
Absolutely. Hopefully you can hear me clearly. So a lot of these cases that are coming this next year are ones that have been touched on earlier in the presentation, so I won't repeat what's already been said. So to start with, Paul, Palmere and Purchase, which Abby touched on earlier, the nervous shock claims as they were. So this is due to be heard in the Supreme Court in May 2023, so May this year. Effectively, the stumbling block in a lot of the clinical and negligence cases, and in the three cases that are going before the Supreme Court, were that effectively the horrific event in this instance, in these three cases, the death of a loved one, needs to be shortly after the negligence. But obviously in clinical negligence, that's tricky because obviously potentially missed diagnoses or negligent failure to diagnose may have occurred months or even years earlier, as in Paul. So it'll be interesting to see how these are dealt with by the Supreme Court, because what the Court of Appeal were clear was that there should be provision for claimants to claim have for effectively nervous shock, secondary victims to be able to claim following these events. But as I say, in terms of clinical negligence, often the timings are longer than perhaps in an accident claim, where it's more likely that the secondary victim would have been present at the time, and that effectively the negligence and the horrific event are as one or shortly after. The next case due to be heard, in fact, next month, February 2023, is the BXB and Watchtower case in relation to vicarious liability. Now, this was a case involving Jehovah's Witnesses, and it was to do with the relationship between the tortfeasor and the claimant, and to do with whether or not the defendant had sufficient knowledge and sufficient relationship with the tortfeasor. Now, in the Court of Appeal, it was concluded that because sufficient power and authority was given or delegated to some individuals as elders, that created the power imbalance, and that creation was effectively the defendant's doing. But it will be interesting because permission has been given to revisit both elements of the test in the Supreme Court, and that, of course, will be hugely relevant going forward. I'm doing a whistle-stop tour, I apologise, but I'm conscious of the time. So Matthew and Hines, we've already heard from Abby And again, I won't seek to repeat this in detail, but effectively the research element, the research in dementia cases is still not conclusive. And effectively what the court said is you can almost find academic research to fit your case, and that's me paraphrasing very much, but because the area is still quite new and very much developing, there's just not the volume of research to create a clear conclusion. And the contrast with this, of course, was the epilepsy part of the claim, where it was clear. So it's likely that this is going to change going forward as research develops. Moving on then to Griffiths and Toohey. This was an interesting one in terms of expert evidence. Effectively, in this case, the claimant had produced expert evidence. The defendant not only didn't produce their own expert evidence, but also didn't cross-examine the claimant's expert. And what the court said is that there needs to be consideration as to whether or not the claimant's report, if that is the only one produced, or the single report, meets the bare minimum standards. So effectively it can't just say we think it was their fault. There has to be reason, there has to be rationale, and it has to be a proper report. But if it is a proper report, we then need to consider what weight can be given to submissions made where it hasn't been challenged either by alternative expert evidence or in thorough cross-examination. And again, that'll be an interesting one for both claimant and defendant practitioners, because it will look at how we need to make sure that we have covered our client's case, whichever side we represent. That one as yet hasn't got a date, but hopefully that will be coming soon. And then just looking at the updates, the sort of not case law, but the Civil Procedure Rules Committee updates. The first one, of course, is the extending of the fixed costs, which I think is due October this year, although these things can often take longer than we expect. But rather than extending the fast track, effectively a new track will be created, the intermediate track, for many cases, including, of course, clinical negligence cases, valued between £25,000 and £100,000. As I say, aiming for October 2023. And then the second change, and it's a big one, and as I say, as Abby said earlier, I'm sure we will be doing a full update when this has come out. Is to do with the quoks, and the proposal that settlements, including Part 36 and Tomlin orders, are no longer in effect, untouchable, and can be the defendant will be able to enforce a cost order against the claimant's damages where settlement has been reached rather than an order made. So it's a very much watch this space position, but hopefully, as I say, we'll have more information later on this year, or into early next year potentially. The one thing I will say in relation to the quoks is, of course, when we are issuing claims now and looking at who to include as a defendant, it's got to be a consideration that those rules are likely to be changed. So rather than the blanket, let's just issue against everybody, a very careful consideration as to who's your defendant it will be needed, to avoid putting your client, if you represent the claimant, at any risk of costs, even if it's a settlement case. And that's your whistle-stop tour of next year, or this year. I forget that we're in 2023.
Thank you very much, Kate. That's really helpful. Right, that concludes the case law update portion of the talk. What I'm going to do is I'm going to stop the recording, and then we'll kind of take any kind of questions that you might have.